So a really important rule that you need to both remember and understand is that past consideration can never be good consideration. So consideration needs to come into existence either with or after a promise. So let me give you an example. Um, and actually, let me slip back just one step here. Consideration can be executory, executed, but not passed. So executory means in this context that it can be required to be performed in the future. It can in fact be already executed, already performed, but it can't be passed. So let me give you an example of past consideration and then we'll compare it with executed consideration. So a good example of past consideration is say I helped my friend refurbish their car, a vintage car. And so I spent hours and hours doing that with them. We had a great time. And then subsequently, they said to me, I'm going to transfer that car to you in consideration of all the hard work you did helping me fix it up. And then they didn't transfer the car. Anyway, so they haven't transferred me the car. Have I got a binding promise there? Well, no, because my consideration there would be past. The promise that was made, transfer the car to me, in exchange for the work that I'd done, was made after the work was done. But let's think then about executed consideration. So something that's already been done. Let's go back to our unilateral contract example where I make a promise to you, or make a promise to the world even, that I will pay $100 to the first person who finds and returns my cat. As we understand that promise isn't binding unless and until the act of acceptance, the finding of the cat and the returning it to me, is actually undertaken. So at the time that the contract is made, your consideration, if you're the one who's gone out and found my cat and returned it to me, your consideration is executed. You've got nothing more to do. And my consideration is executory at that stage. In other words, I have an obligation not yet fulfilled to keep my promise to pay you the $100. A really good place to start with thinking about this concept of the past consideration rule is the case of Roscorla and Thomas, Queen's Bench case from 1842. In that case, a purchaser, or the plaintiff, I should say, purchased a horse from the defendant. The defendant then made a promise after the purchase contract was signed that the horse was sound. As it turned out, the horse wasn't sound, and the plaintiff sued for breach of contract. So the issue then became, was the promise that the horse was of sound quality a contractual promise? Was it part of the contract? And it was held that there was no consideration for the promise that the horse was sound. The only consideration that had been alleged was the contract for the sale of the horse. But this, however, had preceded the defendant's promise. So it wasn't part of the bargain, and it wasn't given in exchange for the promise for payment for the horse. So consequently, it wasn't good consideration. There's another American case that I believe is, from memory, is alluded to in your textbook. So that's Harrington and Taylor, a 1945 case. In that case, the defendant had assaulted his wife, and the wife then escaped to the plaintiff's house. So the defendant then broke into the plaintiff's house and assaulted the wife again. So the wife knocked the plaintiff down with an axe and in fact was about to decapitate him when the defendant intervened, and in the process the defendant's hand was badly mutilated by the act. The defendant survived and later promised to pay the plaintiff for her damages. So the defendant then paid a small sum but refused to pay anything more. This is one hell of a guy. Ultimately, the question for the court was there valid consideration for the defendant's promise to pay the plaintiff's damages? and it was held that there wasn't, but that the promise to pay damages, was voluntarily performed. But the court then pointed out that the defendant really should feel morally obliged to make that payment, but because there was no consideration, that the consideration was past consideration and accordingly not good consideration, there was no obligation in contract to make a payment. Of course, the way that we learn about the rules is by studying the exceptions to them. A case that we discussed in class a couple of weeks ago, I suspect I couldn't remember the name of the case while we were talking about it, is the 1616 case of Lampley and Braithwaite. That's the case where a essentially we've got two lords. One of them is being put away in prison. The other one decides to run around the country trying to seek a king's pardon, was ultimately unsuccessful, and our charged felon languishes in jail and dies. So in that case, the question was whether there was an act or a forbearance that predated a promise that could be good consideration. And in that case, they found that where the act had been done at the promisor's request, so Braithwaite had in fact asked Lampley to run around the country and seek the king's pardon, and at the time the request was made, the circumstances implied that payment would be made, that itself could be good consideration. That is actually supported then by the decision of Powon and Lau Yu Long, which provides clearly that past consideration will be good consideration if it's provided at the request of the promissor and the parties understood that the act would be remunerated, and then lastly that the promise occurred in advance of the act. So had it occurred in advance of the act, there is no doubt it would have been enforceable. That brings us to the next one, which we call the existing legal duty rule. So a promise to perform or the performance of an existing legal duty is not sufficient consideration. Again, we've discussed this in class previously, and we've done that in the context partly of certainty, because a promise of that kind is only illusory. So the promisee is neither giving up or doing anything that they're not already obliged to do or to give up. And so this actually sits very closely next to one of the rules that we'll look at next time around, identifying what certainty is. So an existing legal duty, what is it? So it could be a public duty or it could be a pre-existing contract that you already have with the promissor. So let's start with the idea of the performance of a public duty. Key case here is Glasbrook Brothers and Glamorgan County Council. In that case, basically the facts arose during a coal strike in 1921, and a group of miners were involved in picketing and there had been some violence. The colliery manager insisted that the council provide additional police, and 70 people were there to break the strike ultimately. There was a written agreement under which the defendant, so the colliery, promised to pay some specified amounts for this extra manpower that they got from the police. However, when the police or the council sought the payment, the colliery refused to pay. Ultimately, it was held that any attempt by a public authority to extract payment for normal services should be strongly resisted because the public authority is just performing its public duty. However, if the public authority goes above and beyond, as was the case here, and did something more than the minimum, then they should, and they did so in exchange for a promise that they would be paid for doing so, then that promise should be considered enforceable. And the act of going above and beyond should in fact be acceptable consideration. Another key case in this area is Collins and Godefroy, 1831 case, where it was found that attendance in court, particularly under a subpoena, was not sufficient consideration for a promise of payment for witness expenses. So under because the law requires, the issue of a subpoena requires somebody to perform their public duty and show up in court. As a consequence, a promise that if they show up, if they comply with their existing public duty, they will be paid, fails for want of consideration. So what about the second of those types of past consideration, where there's an existing contract with the promissor? Wigan and Edwards is a nice case in this regard. So 1974 case. In that case, Edwards purchased a new house from Wigan. The contract didn't contain any promise that the house was in a good condition. And it turned out that the house was defective in a number of different ways. And Edwards said that they were not going to complete the purchase, so they weren't going to finalise the contract unless those things were fixed. As a result of the pressure, Wigan then promised, firstly, to remedy some minor defects within 1 week of finance being approved, and secondly, to correct some major defects in the next 5 years. Wigan didn't do any of those things, so Edwards sought to recover the costs. So the question before Justice Mason was, firstly, was there consideration for the promises that Wigan had made, and applied the general rule that a promise to perform an existing contractual duty can never be consideration. However, he qualified this, where the promise to do what the promissor is contractually bound to do was given by way of a benefit or a compromise of a legal claim, then the promissor, having asserted that they're not obliged to perform their side of a pre-existing contract or bargain, and that he has a cause of action under it, may in fact then agree to do something different for good consideration. But the claim itself needs to be honestly made. And that's to prevent people from taking an unfair advantage by making unscrupulous threats to withhold performance under a contract. It doesn't matter that the courts considered that the promissor's claim would have failed if it had been litigated. Edwards honestly believed that he did not have to complete the contract, and even though they might have been wrong in holding that belief, and let's not inquire into it at this stage, let's just assume that they are wrong, that the contract didn't provide for that, their claim cannot be described as frivolous or vexatious, and as a consequence, consideration was found. So the point here is, if one party has a bona fide belief, so not a frivolous belief, but a bona fide and honestly held belief, that they are excused from performing an existing contractual obligation, then performing or promising to perform the obligation could be good consideration for a new promise from the other party. Another couple of cases I really like here include the Stilk and Myrick and Hartley and Ponsonby cases. So Stilk and Myrick is a nice old one, 1809 UK case. Before the start of a voyage, the plaintiff here, so Stilk, contracted to work as one of 11 seamen on a voyage for essentially £5 a month. During the voyage, 2 seamen deserted the ship, and so they were down to 9. So the captain made an agreement with the rest of the crew that they should receive the wages of the 2 deserters if they continued to work the ship on the way back to London. They got back to London, and surprise, surprise, the captain didn't honour the payment. So Myrick didn't honour the payment, and so the plaintiff sued for his share of the wages for those 2 deserters. Lord Ellenborough said that the agreement wasn't enforceable because there was no consideration given by the plaintiff for the promise to pay. The remaining crew were already bound to do that work on the vessel back to London, so the desertions were merely an emergency of the voyage, and the rest of the crew remained bound by the terms of the original contract to bring the ship back. So this case is really good authority for the proposition that promising or performing a duty that you're already bound to perform is not good consideration for any promise that is made to you. One good reason for the rule is it prevents contractual blackmail, where parties threaten not to perform contractual obligations unless they get more consideration down the track. That is not good for trade and commerce generally. It's worth, though, having a look at Hartley and Ponsonby, which is a case of very, very similar facts, yet a very, very different outlook. So that's an 1857 case. And basically it involved very similar facts. However, rather than just 2 of the 11 deserting, 17 of a 36-man crew deserted, and only 6 of the remaining men were competent seamen. Same kind of promise. If we get the ship back, then you'll get paid an extra amount. So with so many crew members missing, it was actually unsafe for the remaining crew to continue the voyage, but they agreed to do it because they'd been promised this extra pay when the ship was docked. When the ship arrived in the home port, Ponsonby refused to pay the crewmen the extra wages. In that case, the judge did pay attention to Stilk and Myrick, but said that the sailors weren't entitled to additional pay in that case because they were performing their existing legal duty. But in this case, the desertion of so many crewmen, compared to the desertion of only 2 in Stilk and Myrick, changed the nature of the remaining sailors' duties to the point where the contract could be considered discharged. So it was so different. It was a fundamentally new contract and a new set of promises. So as such, the offer by Ponsonby to pay the crew to sail back and the acceptance by the crew of the additional pay and the agreement to do that could be considered an entirely new contract and accordingly valid consideration as opposed to past consideration.